May it please the court, my name is Sydney Sheedy and I represent Mr. Tordo within the matter of this case. And through counsel, I am seeking the suppression of photo identification, violation of Miranda, and same or similar acts. Moving to the single photo lineup, this violated the current due process doctrine. According to this doctrine, the admissibility of a photo is determined by the corrupting effect of the suggestive identification. The use of the single photo lineup is the most suggestive procedure, thus has a high chance of corrupting the victim's memories and can lead to wrongful identification. Coupled with the fact that the show-up lineup was shown to both alleged victims at the same time, the suggestibility is compounded. Please find the police identification photo lineup suggestive. Within the police report, some officer who presumed to be Sergeant Albert Tylerson stated that he was requested by the assistant prosecuting attorney to conduct a photo lineup for the females that were involved. He took the single photo to Southside Junior High School, not a police station, and showed Kate Hyde and Taylor Terry the photo of my client. The officer showed Hyde and Terry the single photo together. This is a highly suggestive procedure that can lead to wrongful identification. Due process demands the admission of this evidence to be suppressed. Moving on to Miranda, secondly, the defense moves to the court to suppress all statements of my client that took place at Southside Muncie Police. The client of the undersigned counsel proposed that no person should be interviewed at a police department without warning, since the constitutionality of a state action is the burden of the state to prove objectively. We request this court suppresses all statements without subject review. Mr. Tordo was arrested in the same room after he spoke to the police. Therefore, making the intent of the police department was to make it clear that my client was not free to leave. Everything Mr. Tordo stated was also found within the search warrant. When there is a violation of any constitutional provision relating to a criminal procedure, the evidence gained as a result of such violation may be inadmissible at trial because of the exclusionary rule. Please find that this is the case here. Moving on to same or similar acts in the indictment are more prejudicial than probative. In fact, in the order to protect the integrity of this case, the defense moves for separate trials for each victim. Further, the defense moves all and any statements given by Liz to be ruled inadmissible. This case is not a question of consent, but the age that makes the act criminal. Thus, even though there is an argument to be made that the act was similar, it is not similar enough because Liz was a legal age to engage in sexual relations. As stated in FRE Rule number 403, the court may exclude relevant evidence if it is probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice. This testimony places unfair prejudice on the defendant, misled the jury, and confuses the issues. This testimony wastes the court's time because it is not relevant to the elements of the current indictment. The defense moves the court to see that the prejudicial effect of allowing such evidence outweighs any probative value. In addition, the defense seeks a ruling precluding the admission of any photographs found on the defendant's phone of naked women. Under Indiana law, adult pornography is not unlawful, and since there is no identification by the alleged victims of the said photographs, the purpose in this admitting them is only to mislead the jury. Insomuch, we respectfully request that the show-up lineup of all statements of the accused to be suppressed, and that the court respectfully finds that other demands of the separate trials of the two victims' cases and the admissibility of the other act consenting adult female Liz's facts. Thank you.
So why is it that you're asking for two different trials for the two victims, even though the crime that was committed was under the same roof at the same time on the same day?
Because the two victims are being charged with the same crime, so therefore the jury's going to find each of them of the same crime. So we should move separate trials.
Okay. So tell me how the interview when he went into the police station, how was that coercive?
Well, first of all, when he walked into the police station, he felt as he couldn't leave, therefore in a room, arrested within the same room that he spoke to the police. Also, his mother, he was not allowed to see his mother, and thinking that he is a 17-year-old boy, not being able to see a mother is definitely intimidating.
How was this an interrogation?
Proving the fact of interrogation, he was held for least 6 hours, enough for the department to apply, get granted, perform a search warrant. If he wasn't being interrogated, why couldn't his mother go back into the room that he was being held in? I do not have to prove interrogation. The prosecution's job is to prove the lack of interrogation.
May I please the court? My name is Sam Jaziri, and here are the prosecution's counter-arguments. So first, suggestibility is not an issue here. The defense is arguing that the show blind photo was too suggestible because they only showed one photo to the girls at their middle school. But the prosecution is arguing that it's not suggestible because of the relationship the defendant has with the victims. For example, if you show a picture of somebody's aunt to them, you can show them just a picture of their aunt, they can pick her out, or you can show her that picture of their aunt and 50 different pictures, they can still pick out their aunt from that picture because of the relationship they have. And second, Miranda rights require custody and interrogation, and the defense wants to suppress any statements made by Mr. Tordo because they're claiming that the criminal procedure was invalid because he didn't get read his rights before interrogation. But we're saying that Mr. Tordo didn't need to be read his rights because he wasn't taken into custody. He wasn't formally arrested or deprived of any of his freedoms. So he came in voluntarily, it was just a conversation they were having. He didn't need to be read his rights. And third, the state is not arguing that the defendant acted in conformity. The defense wants Liz's statement to be admissible since she is 18. But we aren't using Liz's statements to show Mr. Tordo's character. We're using Liz's statements to show Mr. Tordo's ID because he does it the same place, uses the same things. And under FRA Rule 404(b)(2), it allows same or similar acts to be used to prove any of the elements, and ID is one of the elements. And then lastly, the prosecution would like to move for the inadmissibility of the lab reports due to the fact that we don't find the lab reports relevant because they show that the victim had sex with other people, which is not really relevant to this case. We just wanted to know if she had sex with the defendant.
Now, whenever the defendant walked into the police station, was he suspect before or after he showed up?
Well, when the defendant showed up to the police station, we didn't even actually know who he was to begin with. So he didn't start out as a suspect, he became a suspect after he talked to us. But he also admitted when he walked in the police station that he had a relationship with the girls, which also goes back to the suggestibility.
Are you denying the fact that there was only one photo taken?
No.
Why?
Well, that's the standard operating procedures of the South Muncie Police Department. And if this case is subject to reversal, then thousands upon thousands of other cases can be subject to reversal due to that's our procedure for every case.
Did you have to do it on school grounds?
We felt like that was they just happened to be at school. We didn't mean to have them be at school, but they just happened to be there.
Would have been more controlled environment to have them at the police station?
We feel like bringing juveniles into the police station kind of like intimidates them and maybe makes them feel on edge. So we wanted to have them in an environment where they felt comfortable and they're used to.
How do you, about the fact that defense raises suggestibility that they were both together? Could this be reflected in how one answered first and then the other way until she responded after?
I mean, we're saying that they weren't suggestible because of the simple fact, like if you show a kid a picture of their aunt, they'll say that's their aunt whether 5 other people before them said it or they answered first. It all has to do with the relationship they already have with each other. They know each other so well. We didn't think it was suggestible.
Okay. When it comes to new photos that were mentioned in the report, were these photos taken voluntarily?
Yes.
Yes. Now, were they taken before, during, or after the incident?
During.
During the incident. Okay. Now when it comes to Liz, you mentioned that they had a relationship, an ongoing relationship. Was that a romantic relationship, a friendship? Which one?
I would say it's more of a friendship.
A friendship. Okay. And was their friendship at all tied to how this attack was carried, or the sexual assault was carried out with him?
No, I would say that her friendship started with him.
So, why is it that he voluntarily went to the police station to talk to them if he was scared of them?
Well, my client is mentally 17 years old, so they were looking for Ziggy, also known as my client, and I believe he was just trying to do the right thing.
By confessing?
He, as I stated earlier, is 17 years old mentally, and therefore he believes that he is not committing a crime that the prosecution is accusing him of.